we're going to call at least this concurrent session to order. For those of you who've just joined us, I'm Darlene Weaver. I'm director of the Theology Institute, and this is the concurrent session that focuses on forgiveness and the law. And we're very fortunate today to have two faculty members from Villanova's law school to join us. And just as in the first session that we had this morning, they're going to come at the topic of forgiveness from balanced session overall. So let me just briefly introduce them in the order in which they'll speak. Patrick Brennan is Professor of Law and John F. Scarpa Chair in Catholic Legal Studies here at Villanova University School of Law. He is the author or co-author of more than 30 articles, essays, and book chapters that study questions in jurisprudence, American public law, law and religion, and Catholic social thought. His books include By Nature Equal, The Anatomy of Insight, and Civilizing Authority, Society, State, and Church. He lectures widely and serves on the Executive Council of the American Catholic Philosophical Association. He's a frequent commentator on matters concerning the online after today. Penelope Pether is Professor of Law here again at Villanova's School of Law. Dr. Pether's recent scholarship focuses on legal theory, comparative constitutional law, the theory and practice of judging, particularly in the U.S. federal courts and in post-9/11 common law constitutional contexts. Dr. Pether is co-author of Criminal Law, Cases, Materials, Strategies, and has published articles in venues such as the Stanford Law Review and Law and Review. She's the editor of Law and Literature and currently serves on the Mazie Dissertation Prize Committee for the Association of the Study of Law, Culture, and Humanities. Again, we're very fortunate to have them with us today. Please help me welcome Patrick Brennan and Penelope Pether.
Thank you very much. It's lovely to be here. Victor and Ike are casual acquaintances. Ike, having recently grown envious of Victor's comparative successes, deliberately takes advantage of an opportunity to knock Victor off his bicycle. Ike is now an injurer. Victor is now a victim. The physical harm to Victor is real, but not too serious. A few cuts and scrapes that don't hurt much. Victor feels the sting of insult, though, and he grows angry. If Ike had knocked Victor from his bike on account of Ike's, having had an epileptic seizure or having been shoved by some third party, Victor's cuts and scrapes would be the same, but he would feel differently. His moral emotions, as they are called, would be different. Or, more to the point, we can agree that they should be different. A random falling rocks hitting and harming me does not reasonably involve my moral emotions. But Ike is no rock, and on my facts, he deliberately deals Victor a blow that has physical as well as psychological and moral consequences. Victor has been harmed in the sense that Ike caused him physical pain. This harm is no different from what would have been caused by that randomly falling rock. And again, we can agree that it would be silly or pathetic for Victor to resent or be angry at the rock having fallen. However, we can also agree that it is not irrational. Indeed, it is eminently rational for Victor to grow angry at the insult, the intentional injury. Even if he does not seek revenge, Victor resents. That is, he feels indignation and anger at Ike for deliberately injuring him. Meanwhile, Ike neither feels nor feigns one whit of contrition. He remains intransigently unrepentant. What should Victor do now? Here we may not so readily agree. My contention today is that Victor should forgive Ike as quickly and completely as is possible, and without precondition. Unconditional forgiveness no matter what. That is the thesis that I shall defend here. My guess is that this thesis will seem as obvious to some as it will seem quixotic or even dangerous to others. Reasonable minds divide on the nature and therefore the exigence of forgiveness. But if we start from the normative anthropology of the central Western tradition, we cannot but conclude, I submit, that forgiveness must be given as unconditionally and promptly as possible. Forgiveness is not a free-floating idea. A conception of the human person must underlie and inform any promising theory of forgiveness. And the human person, as I understand him, is, above all, called to be a lover of self, of others, and of God. Signally, Thomas Aquinas has little to say about interpersonal forgiveness as such, and this is exactly because his focus is love. And, as I shall argue, forgiveness just is the form that love takes when one has been injured. My first introduction to the scholarly treatment of forgiveness was through the work of my former colleague and friend, Jeffrey G. Murphy, one of the foremost philosophers of punishment of his generation. I note this autobiographical point because, as those familiar with Murphy's work know, Murphy manages, as he says, only 2 cheers, not 3, for forgiveness. And that's the kinder, gentler Murphy. In the preface to one of his more recent books, Murphy says the following about his earlier book, Forgiveness and Mercy. Quote, "A colleague asked me if the subtitle of the book was going to be An Outsider's View," close quote. Still, with Murphy's cautions in mind, I would like to put in 3 cheers, not 2, for forgiveness, especially, but not exclusively, by those who believe themselves to be under Christ's model and command to forgive. As I've already indicated, I understand forgiveness to be the form that love takes when one has been injured, where by injured I mean not merely harmed, but deliberately or purposely insulted, belittled, or degraded. But even for the non-Christian, I shall argue, love, properly conceived, is the human act that is most necessary. In a world in which most people, including Murphy, are Kantians, either by profession, Murphy, or osmosis, most of the rest are Kantians by osmosis, mine is a countercultural message. The Kantian fears love as heteronymous, insisting instead upon duty as alone a valid reason for action. But for the Christian, no person acts for bare duty's sake. We act out of love because we have been loved first, in creation and then again in redemption. Having been loved first, we can love ourselves, our neighbors, and above all, our Creator and Redeemer. Before developing my thesis, a brief aside is in order. I was asked to speak about the place of forgiveness in the law, and usually, though not always, people who think that law should forgive have the criminal law in mind, as opposed to the civil law. For a reason that should already be apparent, I'm in the somewhat embarrassing position of holding the view that forgiveness has no place whatsoever in the criminal law, or for that matter, in the civil law. Despite what some of its boosters occasionally claim, forgiveness has no proper place in the functioning of a criminal law system. This denial that forgiveness has a place in the functioning of a criminal law system follows from my claim that forgiveness is a work of love by one who has been injured. It is too obvious to merit argument that loving is not something others can do for us, not something that can be outsourced to the neighbors or that powerful stranger called the state. Love is never, even in the form of forgiveness, an act that someone else can perform on behalf of the one who is called to love. Before turning to the question of how love works as a form of forgiveness, I hasten to say that in putting in 3 cheers for forgiveness, I do not suggest, indeed I would deny, that a robust ethic of loving forgiveness rules out the possibility of just punishment by the state of the offender. Indeed, proportionate retributive punishment may even be, as Simone Weil says, a need of the soul that has received or even experienced forgiveness. Related to this is the fact that further, although loving is not something a legal system can do, a properly designed and implemented system of criminal law can perhaps contribute to identifying when forgiveness might be called for, and thereby to reduce the frequency with which love must take the form of forgiveness. It would do this by condemning and promising punishment for, and thus deterring, immoral conduct. It is better not to have to hope for forgiveness, better also to live in a world in which forgiveness is freely offered, and sublime to be the person who overcomes injury with love in the form of forgiveness. Or is it? Jeffrey Murphy is fond of quoting S.J. Perelman, quote, "To err is human, to forgive supine." That might be true of the false forgiveness that is a form of condemnation of wrongdoing or a manifestation of servile self-loathing by the injured. Forgiveness that is a true work of love, by contrast, cannot but rise to the level of the divine. But if rise it does, thanks to grace, it is also exemplarily a human act. In the words of Lord Edward Herbert, quote, "Forgiveness is the most necessary and proper work of every man. For though when I do not a just thing, or a charitable, or a wise thing, another may do it for me, yet no man can forgive my enemy but myself." The trouble besetting Lewis Carroll's intrepid hunters of the snark was that all they had to go on was the word sound snark. It was an existent about which they had no clues. Forgiveness is the word sound I've been given to explore, and we can approach it by observing the broad agreement that forgiveness is different from forgetting, which is not a moral response at all, excusing, which is discounting what is bad, condoning, which is approving what is bad, or pardoning, which is remitting a penalty in some kind of official, not personal capacity. Though the observation of these differences amounts to considerable progress, it still leaves many questions unanswered. For example, is forgiving the overcoming of revenge, as Bishop Butler famously preached, or is it the overcoming of resentment for moral reasons, as Geoffrey Murphy claims? Or is forgiveness instead, as Joanna North maintains, a conscious attempt to improve oneself in relation to the wrongdoer? Or is forgiveness, as Charles Griswold has argued at length in his recent book, Forgiveness, 2007, to understand, to relinquish revenge and resentment, all the while holding the offender responsible by, in part, requiring the offender to satisfy certain baseline conditions? There are important elements of truth in each of these definitions, it seems to me, to some of which I shall return in due course. However, unlike the account of forgiveness I began to sketch in my introductory remarks, they all, in their various ways, start from an overall picture of the moral life that is, it seems to me, impoverished. Above all, because those pictures slight the place of love. Love, God's being love, is, of course, perhaps the fundamental claim of the Christian religion and faith. And this may lead some to suspect love of being relevant only to Christian understandings of human living, including that phase of human living called forgiving. Quite simply, as Josef Pieper asserts, forgiveness is one of the fundamental acts of love. But I think that here we need to begin to distinguish, in order to reunite, types of love. A first distinction to make is between natural love and supernatural love. Beginning from a phenomenology of the moral life on the natural level, we will be in position to proceed to an account of the moral life on the supernatural level, where grace builds on and does not destroy nature. Let me be clear. I'm trying to understand forgiveness by understanding love. And it seems to me, how love is understood follows from how human nature is understood. My argument depends upon, first, there being such a thing as human nature, and the properties I shall impute to it as I go along, and second, human nature's being not only created, but also graced, that is, raised into a supernatural economy of happiness. Unlike plants and brute beasts, human persons do not realize the potential of their created nature automatically. They must choose and will it. And for every human being that attains the use of reason, this process of winning oneself by becoming in act what one is in potency has a temporal beginning. In the context of determining whether before children have the use of reason, it can be said that there is in them either venial or mortal sin. Thomas Aquinas observes that when the child begins to have the use of reason, he is not entirely excused from the guilt of venial or mortal sin. Then Thomas continues immediately to the crucial point. Quote, "Now the first thing that occurs to a person to think about at that time of attaining rationality is to deliberate about himself. He thinks first of himself, not of others, not even of God. What he must do, Thomas explains, is to direct himself to his due end." Commenting on this important passage, Thomist philosopher Jacques Maritain says the following: "This act, the first act of freedom, is a moral act par excellence. In this primal act of freedom, the child asks himself, what do you live for? What do you live for? Stated in the philosophical terms of which the child is not yet capable, the answer is his good, that is, his last end. Stated differently, in terms closer to those of the child's inchoate understanding, the answer is happiness. It is Thomas's view, which seems obviously correct, that we do all that we do for the sake of happiness. We are frequently mistaken about what will make us happy, but everything we seek under the aspect of the good or what will make us happy. Why do we, each one of us, inexorably seek our own happiness? The Thomist answer is this, quote, every natural being possesses a determinate nature, and in accord with this nature, a determinate, innate drive or striving for his own perfection. On Aquinas' teleological understanding of the universe, each created being possesses appetite, an inner tendency or inclination that moves it toward its proper perfection. Quote, I'm now quoting Joseph Pieper, one who comprehends man to the depths of his soul as creatura simultaneously knows that in the act of being created we are, without being asked, or without even the possibility of being asked, shot toward our destination. Therefore, a kind of gravitational impulse governs our desire for happiness. Nor can we have any power over this impulse because we ourselves are it. While all different kinds of creatures share analogously in the function of being internally directed to their own fulfillment, at the apex of all the levels of appetite there stands the human will. Thomas posits that the will's most fundamental inclination, its natural inclination, is toward happiness, the fulfillment or perfection of the rational being in which it is found. The will of the human person is free, but motored by an appetite toward that individual person's fulfillment. All of this has profound consequences for how we understand love, which is our key to forgiveness. Our created natural desire for beatitude is itself a natural self-love. According to Thomas, love is an appetitive activity and, in fact, the most basic of all such activities. This means that love cannot but be a function of the underlying inclination toward individual personal perfection. In every act of willing, including the willing that is loving, the individual seeks his or her own perfection. It is not surprising, then, to find Thomas saying that the object of love is always one's own good. Now, as I've already mentioned, all natural kinds are by creation shot through with an arrow toward their ends. For Thomas, this means saying analogously that all natural kinds, not just humans and angels, love their ends. Love is always a transitive affair, and proper love, according to Thomas, depends upon a proper proportion between the lover and the loved object. As Thomas sees it, love is found analogously throughout creation in things animate, such as angels and antelopes, and inanimate, such as rocks. Amor is what Thomas calls the inner source of things' inclinations. Things, both animate and inanimate, have those inclinations in virtue of being created as the kinds of things they are. They and their objects are in a proportionate or fitting relationship. When we turn our attention now to cognitive beings, and prescinding from some important distinctions for which time does not allow here, we note that Thomas distinguishes between the love of which we have just been speaking and the additional form of love of which only rational creatures possessed of will are capable, and this he calls dilexio. This is a love over which the rational person has a choice. It's up to him to decide whether to love or not to love. At the level of sense appetite, a person will be inclined toward goods according as they present themselves at the level of sense. At the level of rational appetite, by contrast, the person can pursue these only under the aspect of the good. That is, at the rational level, she can pursue them only if she judges them to be good for her. So, at the sensible level, I'm attracted to a second ribeye. At the rational level, I can pursue the second ribeye only if I can judge it to be good for me. In sum, dilexio consists in a complacency or enjoyment or delight in the known good object, and it gives rise to the desire either to be united to the loved object or to the joy one takes in the object if united to it. Finally, Thomas distinguishes two kinds of dilexio, and with this we come to the first chamber of the heart of the matter. In his treatment of the passions in the Summa Theologiae, Thomas raises the question whether love is suitably divided between love of friendship and love of concupiscence or desire. And he replies, quote, "I answer that as the philosopher says in Rhetoric Book 2, to love is to will the good for someone. In this way, then, the motion of love tends toward two things, namely, toward some good which someone wills for someone, either for oneself or another, and toward that person for which one wills that good. Thus, one loves the good that is willed for the other with love of concupiscence, and one loves that person for which the good is willed with a love of friendship." The form of love that is dilexio, then, is directed first to a person, what Thomas calls love of friendship, and second to the goods for that person, love of concupiscence. To be clear, love of friendship is not limited to what we commonly refer to as friendships. The term denotes simply the love of a person by which he has complacence in the other person as good in himself, and consequently wills goods for that person's sake. As Joseph Pieper explains, in this sort of love, the lover says, "It's good that you exist." Sometimes the lover says this to the other subsistent beings whom he loves. But as Pieper notes, quote, "To whom do we refer the expression instantly and with sincerity, if not to ourselves?" And it is on the basis of this prior loving affirmation that we will then love with a love of concupiscence what is good for us. The love of concupiscence is, so to speak, derivative, and the good found in its objects is loved as the good of the person to whom they are referred. This rank ordering reflects the fact that for Thomas, only subsisting beings, not their perfections or accidents, can be loved for their own sake. In sum, we can return to our starting point in the natural desire which each person has for what will perfect him. What we can say is that every rational person loves himself with a love of friendship, that is, as a subsisting person for whom goods are desired. What we can also say derivatively is that every rational person loves with a love of concupiscence his own happiness or fulfillment. All this has much to teach Victor and Ike. I start with Victor, the person the conventional analyses would suggest should, perhaps cautiously or on condition, forgive Ike. But before Victor can respond appropriately to Ike, he must take himself in hand. Ike's deliberate decision to take Victor down a peg or two has begun to have the effect of putting Victor on a slide from virtue into vice. Whereas before the incident, Victor was calm and well-disposed toward both himself and the world, Victor has now become an angry, resentful person. Out of love of friendship for himself, Victor is called to say to himself, "It is good that you exist. Stop being angry." Victor is further called to love with a love of concupiscence the perfections that are proper to him. Out of proper love of himself, Victor is to seek to return from a vicious state to a virtuous state. Many theories of forgiveness condition the act of forgiving on the apology, repentance, or contrition of the victimizer. The account of forgiveness I've developed here necessarily excludes the possibility of conditioning forgiveness. Why? Because forgiveness must start in the act of self-love, and each person's call to self-love is unconditional. There's no conceivable reason not to love oneself, because to love oneself is to affirm that one is good and in need of the perfections of virtue. To be sure, as long as Ike the injurer does not apologize, repent, or have contrition, he will be in a bad way. But as Herbert McCabe, OP, explains, this failure on the part of the injurer is no reason for the injured not to begin to do what is necessary for himself. Father McCabe writes, "We can forgive our enemies even though they do not apologize and are not contrite. In such forgiveness, we are changed. We change from being vengeful to being forgiving, but our enemy does not change. Our proper love of self requires that we give up those vicious emotions of hatred and resentment that are not good for us. Before we can will our injurers good, we must will our own." But enough about Victor's self-love, in which, for his own sake, he has begun to overcome hatred of Ike. How does this foundational love, which I've been describing, finally become the basis? He does not teach that we love others only instrumentally to our own goods. On the contrary, Thomas teaches that persons do and should love others for the other's sake. But how is this possible? With this, we come to the second chamber of the heart of the matter. Thomas teaches the priority of self-love, but he does so without sinking into egoism. This is possible because, according to Thomas, our judgment of our unity with others, based on similitude, based on our sharing in human nature, causes us to love those others with a love of friendship. In his discussion of the causes of love in the Summa, Thomas writes, "The first kind of similitude causes love of friendship or benevolence. For from the fact that two things are alike, having as it were one form, they are in a certain manner one in that form, as two men are one in the species of humanity, and two white persons in whiteness. And therefore the affection of the one inclines toward the other as toward that which is one with himself. He wills the good for him as he does for himself." In other words, the unity of affections that constitutes love of as a result of this judgment, a person is moved to take the other person at the level of affection as another self, and so to desire and seek, with a love of concupiscence, that other person's good. Crucially, if a person were blind to his own goodness, he would be blind to the goodness of others. If a person found nothing lovable in herself, she would not be able to love others. Love of others depends upon self-love. The extension of self-love to include others occurs when we see that other person as another self. Here we have an account of self-love that affirms the priority of self-love, but without flirting with egoism. The self that loves itself with a love of friendship will be moved to love others with a love of friendship, and following upon that, a love of concupiscence for those others' goods. Where conventional analyses would raise the question of whether, and if so, under what conditions, if any, Victor should forgive Ike, the stage has been set for me to say that Victor should post-haste and necessarily first love himself and then extend that self-love into a love for Ike. First a love of friendship, and then, derivative of it, a love of concupiscence. The extension of self-love into love of the other happens automatically, as it were, upon the perception of similarity. Unless we block that perception, we will take the victimizer as another self and will with a love of concupiscence what's good for him. Roger Scruton has written that Charles Griswold is right to condition forgiveness on contrition, lest, as Scruton writes, the forgiver have shown no recognition of the fault, close quote. But this is a non sequitur. Since absent fault and the recognition thereof, there would be no reason to forgive. Again, we don't need to forgive rocks, no matter how much they harm us. Moving toward the conclusion. The literature on forgiveness makes much of the question of the difficulty of forgiving and frequently supposes that sometimes people will be simply unable to forgive some injuries. Is it possible that we are incapable of what is required of us? In order to address this question, I would like briefly to return to a distinction I made at the outset. I distinguished between two types of love, natural love and supernatural love. I did so in order, in the end, to reunite them. From the Catholic Christian perspective, we, all of us, come to the tasks that are ours by nature always already graced, always already caught up in a supernatural economy in which grace builds on nature. From an opposing perspective that lacks the element of grace, but affirms a natural version of the teleological view I've developed here, one faces the problem that Bernard Williams called, in a deliberate oxymoron, moral luck. The point was that what mattered most, moral achievement, understood as eudaimonia, was available only or more to the lucky. Deploring this feature of Greek teleological ethics, Maritain noted an alternative, quote, "The great novelty introduced by Christianity is this appeal to all, to free men and slaves, to the ignorant and the cultivated, adolescents and old men, a call to perfection which no effort of nature can obtain, but which is given by grace and consists in love, and from which therefore no one is excluded but by his own choice." In our context, where our happiness has been disrupted by deliberate act of injury, we can say that it's God through Christ who makes our loving forgiveness of others possible and exigent. We do not have to exaggerate or falsify the level of our control over our moral emotions in order to say forthrightly that every rational person is capable of doing what is required. As McCabe explains, all that God asks of us is that we put aside the barriers, the illusions, and the timidity that stand in the way of accepting his love. All that he asks is that we relax and let ourselves be filled with his love, which eliminates our sins and makes us channels and bearers of his love and forgiveness to everyone. We do not have to be perfect, nor do we have to pretend that forgiving will be easy. But we do have to love ourselves in a way that allows God's love to reach us and thereby others. Sometimes we will not be able to resume relations with our injurers. Sometimes we will. Regardless of whether we're in position to resume such relations, forgiveness, the love of other, will be complete when we have sincerely willed his good as much as it is in us to do it. In conclusion, if you're still asking yourself, why forgive? Consider theologian Timothy Jackson's answer. Once we comprehend forgiveness as eternity's work of love, as a good gift given from above, we are free to get on with our life's work. Close quote. Such work does not condone the offense. It recognizes that the injury has been committed and needs to be responded to as what it is by persons such as we are, potential lovers. It rejects the view of those, such as Murphy, that we have to hold ourselves and our human dignity together with a protective grudge-bearing. It is we who love our enemies, but it is not we who make it possible. As theologian Marilyn Adams explains, divine generosity meets the creature's efforts to forgive as completely as God forgives with miraculous aid, enabling the victim to forgive. And so, at bottom, forgiveness is a gift bestowed on victim and offender alike, a beautiful aspect of human life, a sign of a benign universe. Christians would say, an advertisement of its gracious maker. Thank you.
Today, or talk about today, is in the tradition in which I work, inevitably, the work of what we call a situated subject. Like my colleague Professor Brennan, I approach the subject of forgiveness in law as a scholar and teacher of criminal law in particular, and of public law, that part of law explicitly to do with the relationship between state and subject in general. At another plane of particularity, I approach the question, or problem, because I conceive of it as a problem, of forgiveness in law, as a teacher and scholar both of comparative constitutional law and of the interdisciplinary field of law and literature. Let me start with criminal law. I take the conventional theories of criminal punishment, retributive and utilitarian, to be at best peripherally engaged with the problem of forgiveness of wrongdoing. I take the seminal work of Geoffrey Murphy and Jean Hampton on theories of criminal punishment, on which Professor Brennan's paper today touches, to be in a degree of opposition to my perspective. Murphy's contribution to the retributivist philosophy of punishment is most famously his qualified defence of hatred of wrongdoers. His work on forgiveness comes later, after his lengthy exchange with Hampton, and in this he differs from other important retributivist theorists of punishment. After his Damascene journey, Murphy conceives of forgiveness and its relative, mercy, as existing in a shifting degree of tension with a moral imperative to retributive punishment of criminal wrongdoing. And his consideration of forgiveness, what he calls forswearing resentment on moral grounds, also sounds in aspects of conventional thought about criminal responsibility and punishment for criminal acts. For Murphy, at least at this point in his career, forgiveness of the criminal may be grounded in the criminal's repentance, in meaning well and doing wrong, which I take to coincide with justification defences for crimes, in adequate suffering, which I take to be more or less identical with expiation of guilt, or with the undergoing of ritual humiliation. I take repentance, suffering, and ritual humiliation all to serve the interests of retribution. Justification, that is, the theory of criminal defence that says I did it but I wasn't wrong to do it, for example because I was acting in self-defence, is one of two bases on which a criminal actor may be spared adjudication of a criminal responsibility. and at least arguably it has a closer relationship to retributivist than to utilitarian penal theory than does its counterpart excuse, which is the position that says, I did it, the crime, but I wasn't responsible for my act, for example, because I was insane. Nonetheless, for Murphy, forgiveness is both earned by the justly punished criminal and is signally private rather than a public legal or legal institutional virtue and practice. Much of the philosophical work on forgiveness, which I'll touch on in these remarks, I think that its apparent orientation around the personal or interpersonal rather than the institutional, around intersubjective relations, fails to register its abstractness. If I am right, and equally abstract conventional theories of retributive and utilitarian punishment for crimes have little connection with forgiveness, however, some more recent developments in criminal law and practice suggest that discourses on and practices of forgiveness have come to find a place in adjudication and punishment of what I'm going to call conventional crime. I'm thinking here of the relatively recent phenomenon of the victim impact statement, which is now part of the ritual and institutional discourse of criminal sentencing, in which forgiveness and or its lack are prominent, and which serves both retributivist ends and also punishment tethered in commitments to individual responsibility partaken. Especially in the case of death penalty sentencing, the media often reports on victim impact statements delivered by the victim's family. And while revenge and unforgivingness of abject loss and human pain often characterise these statements, sometimes we encounter reports of what strike many, although not perhaps some well-schooled Christians, as remarkable, the expression of forgiveness. Likewise, with the movement to design and implement reparative or restorative justice techniques for responding to crime, bringing offender, victim and community together in fora for adjudication of crime and restoring what is damaged in the commission of crimes. The most notable and successful of these programs have been developed in cases of juvenile offenders who are members of traditional communities, for example, Maori juvenile offenders in New Zealand. These responses to crime partake in retributivism and utilitarianism, it's true, and place emphasis on individual criminal responsibility. But they also have a communitarian aspect that marks a shift from purely individualist understandings of criminal responsibility. Like victim impact statements, they too make a place for the voice of the victim of crime that conventional models of crime and punishment, with their orientation toward the criminal and his responsibility to the state, do not. That binary of individual and state returns me to another aspect of the grounds from which I understand problems of law and forgiveness, those aspects of my work in comparative constitutional law that deal with inheritances of and responses to founding national inequalities, with violence visited by powerful institutions and institutional actors on the powerless, and with constitutional states of exception, theorised by Carl Schmitt, the political theologian of Nazism. Let me call these categories of crimes against humanity injustice meted out under colour of law. Injustice meted out under colour of law. Both interest in Schmitt's work and the state of exception have seen revivals recently in Western philosophy on the one hand and practices of Western government on the other, that might not have been anticipated in the early wake of events in Germany between 1933 and 1945 that, among other things, gave us the theory and practice of modern human rights and humanitarian law. Much has been written about forgiveness in the context of the Holocaust and associated genocides. The work of Vladimir Jankelevich, beginning with his final chapter of Le Mal, published in 1947, and culminating in his two last books, Forgiveness from 1967 and L'Imprescriptable, or The Unforgivable, in 1970, is among the best known. Others would award that honour to Hannah Arendt. Work on law and forgiveness also includes questions of the appropriate responses to be made by states citizens and legal institutions and actors to the inheritances and inheritors, say, of chattel slavery or genocidal practices, including dispossession visited on Native Americans in this nation, or the violent dispossession, de facto enslavement and genocide of Indigenous peoples in Australia, and on whether reciprocal forgiveness by members of these blighted and marginalised communities is a necessary or appropriate part of what must be done to heal the constitutive national defect, originary sovereign violence of racial exclusion that is characteristically denied and forgotten by those in power. In his work on slave reparations, for example, Royal Brooks argues that the US government should provide both reparations and atonement for atrocities against black Americans under slave law and Jim Crow, and that while atonement is a necessary precondition for forgiveness, what he identifies as a duty to forgive is neither a moral imperative nor a moral prerogative. Rather, for Brooks, it is a civic duty. Civic forgiveness, he argues, is necessary for racial reconciliation and black progress. Work on law and forgiveness also includes the theory and practice of an emergent staple of the repertoire for addressing what is often euphemised or impoverished in the description constitution making in post-conflict states, including South Africa and East Timor, that is, the Truth and Reconciliation Commission. In No Future Without Forgiveness, Desmond Tutu likewise conceives of forgiveness of the perpetrators by the victims as critical for reconciliation. He mobilises the Zulu word Ubuntu to signify what Mark Sanders calls the radical reciprocity essential to human being, of a kind that recognises the human being, the humanity of the other. Such acts of state violence are legal problems of a scale and a nature that the ordinary processes of criminal laws and punishments are often conceived of as unequal to. Thus, the mechanisms of truth and reconciliation commissions, extrajudicial commissions of inquiry, Human Rights Commission inquiries, special international tribunals, and so on, which are characteristically convened with such questions of punishment, revenge, atonement, and forgiveness. While these classes of cases may include conventional criminal conduct, and they frequently do, they also have as a characteristic the exercising against individual subjects by the state and its institutions, which may include legal and or military institutions and others, of violent oppression, frequently unlawful and fundamentally unjust. That state violence is also frequently phenomenological. I'm quoting Michael Kirby on the Australian High Court there. That is, it targets individuals because of something that is or is conceived to be essential to their being, inherent to their personhood, such as their race or their religion or their ethnicity, for example. Paradoxically, then, it denies their humanity, reduces them to what Giorgio Agamben calls bare life, beings who can be killed but not murdered nor yet sacrificed. Additionally, it is exercised through and by other subjects, fellow human beings of those denied their humanity, who operate in positions of comparative power within such institutions, including frequently legal institutions. I should note in passing that while as a constitutional lawyer I am particularly concerned with state institutions in general and legal institutions in particular, there are other examples of powerful institutions which, through powerful institutional actors, violently oppress the powerless. What they have in common, I would suggest, is their failure to recognise the other. A failure of what, following the Jewish philosopher of ethics Emmanuel Levinas, has been called the ethics of alterity, the ethics of intersubjective relations with persons other than ourselves. My own recent scholarly work has focused on a particular set of instantiations of such unjust state violence. These include the increasing institutionalisation, especially post 9/11, of the state of exception, in places and institutions including Guantanamo Bay, sundry military brigs within the littoral borders of the US, not least from the conclusions of the Competent Status Review Boards recently employed to clear out evidence of the damning fact that many detained in Guantanamo were not plausibly detained as suspected enemy combatants, as from the recent flurry of federal court decisions involving 17 Uyghurs still detained in Guantanamo, of whom the government has conceded that it has no reason to believe that they are enemy combatants, but whom it does not wish to release. That we, or a national government with claims to majoritarian democratic legitimacy, are unlawfully detaining people in inhumane conditions for extended periods of time with no clear end. To take the case of the Uyghurs, Chinese Muslim subjects of Turkic descent, subjected to severe oppression in China. If the US government succeeds in its attempts to prevent a federal court from ordering their release into the US population, which a federal district court judge has ordered ought to happen, it is unclear where they might be released and thus whether they will ever be released. They cannot be returned to China without significant risks to their liberty, if not their lives, and it was only after a protracted search that our government was able to find a nation, Albania, which would accept 5 Uyghurs previously released without charge from Guantanamo. Just imagine for a moment how you would feel in the circumstances of one of those Uyghurs, held in prison for 7 years without charge in grim conditions which likely included torture, with very limited access to legal representation, subjected to a Kafkaesque procedure made up as the authorities administering it went along, and thus subject to radical uncertainty about what would happen to one. Cut off from home, community, family and friends, at least for the period of one's incarceration, with the possibility that if one was finally released to Albania or its moral equivalent, the likelihood of seeing one's family and friends again was in question, potentially subject to indefinite detention without charge in Guantanamo or on US soil. Or imagine experiencing what continues to be experienced by Ali Saleh Kala Almari, a legally resident alien arrested on US soil, detained in military custody on US soil for 5 years without trial and without seeing his, such as Mahara, a Syrian-born Canadian citizen, who, notwithstanding the fact that, as a Canadian Commission of Inquiry concluded, there is nothing to indicate that Mr. Arar committed an offence or that his activities constitute a threat to the activities of Canada, was seized by US authorities while lawfully transiting through the US, rendered to Syria and tortured. These events devastated both him and his family. There is then the question of whether some crimes, including enslavement, genocide, indefinite imprisonment without trial, and other violations of human rights, may be unforgivable, especially when they are committed by legal subjects and through powerful legal institutions, unjustly deploying state violence against dispossessed others. This question is complicated by what is suggested in the case of Mr. Almari, as indeed, if we think historically, by the genocide practiced by the Third Reich and much of the state violence enacted under South Africa's apartheid regime. That is, that the apprehension of criminality and the criminal is, like this paper, situated in particular places and times. What does the scholarship of thinkers who have thought and written about forgiveness in context of this kind say about the relationship between forgiveness and this category of unforgivable crimes? And I'm borrowing from Hannah Arendt there, as from Vladimir Yankelevich. Most theorists of forgiveness, like Archbishop Tutu and the Book of Isaiah, insist that forgiveness is not identical with forgetting. Some conceive of forgiveness as a moral duty. Others locate moral infirmity in it. Still others consider it a moral prerogative rather than a moral duty. Many conceive of its morality as being conditioned on the remorse, apology, reparation or atonement of the perpetrator. Much of this work focuses on the reparative function of forgiveness in re-establishing first ethical intersubjective relationships and, over time, genuine community. Emmanuel Levinas's work on forgiveness invokes it as a generator of such ethical intersubjective relations. He calls for an ethical response to evil, which solicits from the ethical subject a recognition of the other. And yet, he dedicates otherwise than being or beyond essence not only to those friends killed by the Nazis, but also to all victims of what has recently been called the politics of hate, and which he calls victims of the same hatred of the other man, the same anti-Semitism, even when it's not applied to Jews. As Bernard Waldenfels writes, the polar air of violent death penetrates this book. The faces that the author addresses are already effaced. Yankeliewicz's work on forgiveness contains a similar contradiction. While he argues that France should not pardon Germany for war crimes because to forgive the nation that perpetrated the Holocaust, an imprescriptible, that is unforgivable, crime against humanity, would be a new crime against the human species, in his philosophical writings, he denies the existence of an unforgivable act. Some of Yankeliewicz's glossators suggest that this apparent contradiction can be reconciled if one registers that his theory of forgiveness holds that forgiveness exists outside systems of justice, norms, law, and ethics. It lies in the intersubjective realm. Like love, forgiveness lies in a realm beyond ethics and justice. And yet, as Yankeliewicz's writes, forgiveness died in the death camps. For Jacques Derrida, this contradiction in Yankeliewicz's writings remained unresolved. For Derrida, speaking, like me, at a conference at Villanova, in his case some 11 years ago, genuine forgiveness is only possible when forgiveness is faced with the unforgivable. And yet, in the world, forgiveness is always mediated through reconciliation, that which it is not. As John Caputo, Mark Dooley and Michael Scanlon acutely note, this account of the relationship between forgiveness and reconciliation mirrors Derrida's account of the relationship of the force of law and the possibility of justice. Where does this leave me on the question of law and forgiveness in the particular context of unjust state violence done under colour of law of the kind that I've described? First, it leaves me sharing some ground with Yankeliewicz's. Forgiveness is ineffable, mysterious, a quality of the realm of love, unlike law. It does not partake of the normative order of law, nor yet that of justice. Second, to the extent that the kinds of violence I have described are committed in the name of and with the power and authority of the state, sorry, get rid of that tickle in my throat. Second, to the extent that the kinds of violence I've described are committed in the name of and with the power and authority of the state, they are not amenable to reconciliation of the intersubjective kind that we see in Levinas's work on forgiveness. I want to suggest this may be particularly the case in extended historical contexts, such as the inheritances of chattel slavery in the US and dispossession and genocide of Indigenous peoples in Australia. Because the people who did the perpetrating are dead, but the people who are experiencing the violence, many of them are dead, but generations of them continue to survive. Finally, to the extent that it is perpetrated by subjects who are the vectors of institutions and discourses that deny the humanity of the other, forgiveness may be too much to ask, even when, as there is no sign will happen in the annals of the War on Terror, the perpetrator atones. With Yankelevich, we, or rather they, may conclude that both we and they cannot forgive and be just. As Derrida reflected on Yankelevich's response to an expression made to him of atonement for the Holocaust by a young German, and Yankelevich's response was that he asked that he be excused from forgiveness. Perhaps what will be called reconciliation in the future will always be forgetting the dead. Or, as the survivor of Auschwitz and torture, Jean Emery writes, adequately accounting for the violent victimisation of others that is the telos of the politics of hate, lies beyond the question of guilt and atonement. Memory abides in Emery's work. Forgiveness never makes an entrance. Let me conclude with an insight drawn from interdisciplinary studies in law and literature, for which Robin West makes this case, that one can find in canonical works of literature philosophical insights about the meaning of law and the promise of justice. In Ian McEwan's novel Atonement, a meditation on crime and punishment, innocence and guilt, atonement and the unforgivable, that complicates the question of criminality in ways akin to those I've suggested the annals of the War on Terror do. The responsibility of legal actors for the doing of justice or injustice by legal institutions is forcefully asserted. So too is the special vulnerability of others to state violence, especially in times of national emergency. The novel's temporal setting brackets World War II. This and its opening epigraph from Northanger Abbey suggest its engagement with what the Holocaust signifies and its insistence that lessons be brought home. The novel derives much of its force from its bleak revisionist account of the promise of literature, celebrated most characteristically by the poets of the Renaissance, that literature and love are the only antidotes to death. Bryony, the victim of the novel's story the villain of the novel's story within the story, who lies for a tangle of self-serving reasons and sees her sister's true love convicted of a rape she knows he did not commit, tells stories to herself until oblivion about her capacity to atone for the injustice for which she is responsible. Too craven to write the truth about the real rapist, she instead writes a novel in which she atones for her crime that is institutionally not a crime by fictionally reuniting the blighted lovers, and in which she represents herself as atoning by finally telling her victims the truth of her lie, only to meet with their unforgivingness. In the realm of the novel's real, there is no reunion, but death alone in war. And there is no confession, no atonement. The very possibility of atoning for injustice that denies the humanity of the other is thus cast into question, as is the nature of human subjects who participate in such unethical inhumanity. Engaging with the incommensurability of evil, Bryony, a final act of kindness, a stand against oblivion and despair, to let my lovers live and unite them in the end. I gave them happiness, but I was not so self-serving as to let them forgive me. Thank you.
Thank you so much for those two very, very rich presentations. We have some time for questions and so on, and again, I can ferry the mic around the room so that our speakers and others can hear your questions. Is there anyone who...
I have a question for Dr. Prather. I've been a prosecutor for 17 years, and I've witnessed about 500 victim impact statements.
Right.
In 5, the victim has forgiven the perpetrator, and I deal exclusively with child rape. It's a very heated situation.
Yeah.
In only 2 instances, the judge, and there's always problems with over and under inclusiveness with any legal norm.
Yeah.
Is that a hybrid between institutional forgiveness and the individual motivating that individual intersubjective forgiveness? I just think it represents something very different.
I think you're right, actually, to conceive of it as a hybrid between those two models, and I'm really interested about the low number of examples of forgiveness that you've seen. I'm also really interested that when you've seen it as occurred in the context of child rapes. One sort of subset of the scholarship on forgiveness suggests that it's produced by particular institutional forces and imperatives to resolve legal problems. There's I've quoted briefly from a book by Mark Sanders on the truth and reconciliation. Forgiveness and responsibility and institutional forgiveness and responsibility operate there. I just would always raise the question there of unless they are adult survivors of child rape, and even then I'd probably raise the question of agency and power relationships. Some of my own recent work on rape suggests that when the law does things that we take to be very different in order to try to respond to injustice and under prosecution, under conviction and so on, that's a sort of tool of biopolitical control of populations. In other words, that what's happening there is the work of legal institutions doing what they need to do symbolically, and that really the victim doesn't get an enormous amount out of it. But that's probably way too complicated. But I'm really glad you raised that. Thank you very much.
A question directed to Professor Brennan. When you talked about Victor should be forgiving Ike, what I was hearing based on his use the word similitude. I wonder if you could talk a little bit more about that, whether it's, I guess I jumped to a conclusion, Victor was perceiving Ike as simply another human being, therefore he should forgive. Are you seeing any steps or process by which Victor discovers, because that's a process in Victor's mind, how is he going to discover Ike's mind, so to speak, to take it beyond just a physical similitude? And I'm coming at this because I engage a lot in mediation and wonder if you see steps such outside the legal system strictly, like mediation, as a way to help that forgiveness process and that understanding of similitude.
Your question gives me an opportunity I would have liked to have had in the paper to amplify the point. I think you're certainly right. In the passage I read from St. Thomas, he mentions two kinds of similitude in sharing the form of humanity, and then he says, and also people who are both white. And in the more elaborate treatments of the phenomenology, it's not just the discovery of shared humanity in the abstract sense of possessing the essence of humanity. It's discovering that through also discovering through all the accidents, all the predicates, all the properties that create the texture of a full human being and full relations, and allow us to understand. We never experience people just as human essences. We discover humanity through all the properties that are not themselves what matter most. And so certainly on an affective and a cognitive level, we come to understand the fundamental and unquantifiable importance and the fundamental goodness of a person through all those discoveries of accidents. And the more affective and cognitive opportunity we have, the more guidance we will have, the more leading us to that harder to discover basic goodness. And in that one of the passages I quoted from Father McCabe, and in parts where he elaborates it a little more, it reminds me very much of what my colleague Professor Pether was saying, coming out of the work of Professor Tutu, or Bishop Tutu. These are discoveries that we have to make that can be hard, but we have to trust that we're discovering something important. Is that?
I'm almost like, does the law prevent us sometimes from making that discovery?
Well, I do think that there's the risk that an aggressive criminal law system, and our Anglo-American, I'll just speak about our American criminal law system, is certainly aggressive in the sense of punishing far out of proportion to the rates of punishment in other Western nations, can create the illusion that the only thing that needs to be done after an act of injury that's deliberate is the operation of the criminal justice system. But as I was trying to suggest, and by the way, the reason I knew Professor Heather was going to talk on the topic she did, the reason I took the seemingly trivial example of Ike and Victor on the bicycle is to show the way in which, and your question implicates this, many of us can get hung up on life's basic tasks over little things like that. And if we don't, I think this through in terms of things with which we are very familiar, we won't have adequate guideposts when we come to the writ large cases that Professor Heather indicates. And I think it was Father McCabe's work which grew out in many respects of his work in the confessional about when people were wasting themselves and their lives, that got me to thinking about the reasons for forgiving. And I had, until I began thinking about it, thought that forgiveness was always already just a kind of almost irresponsible act of agape, self-giving. But no, it has to be something that creates a repair where the immediate harm starts.
I have a question for Dr. Heather. And it relates to your reference to Bishop Tutu and the reconciliation work that he did in South Africa. I have an ongoing, continuing interest in South Africa, and I read the newspapers daily. Mm-hmm. And it seems to me that there is a continuing social reflection on the part of ordinary South Africans about what they've been through. That someone demonstrated that they were telling the truth. That before a body of their own peers, they had to come forward and tell their story in a way that would, almost like before a jury, but in terms of a panel of peers, and then be given amnesty. Some people chose not to come forward, and some people were denied amnesty. And in terms of recognizing your topic of forgiveness and the law, the society gave a formal extension of forgiveness to those people that stepped forward. They did it on the basis of an act of Parliament that established the commission, which gave them the framework of law. But there seem to be a lot of people who haven't accepted that. And I wonder if there's a way, people constantly ask me, are there ways that we can create something like a truth and reconciliation process to heal some of the deep divisions that still exist between us as people without having it all go to court. I just wonder what your reflections would be about how we could apply some of that in a way that would have some real traction with people today.
I think there's a lot in what you say, and I think certainly one of the starting points for a process of reparation or atonement that might produce might be met by forgiveness and then might operate beyond the individual to heal deep social rifts and address deep historical injustices. I also think it's really interesting there that although the Commission was set up by an Act of Parliament, like much of what you read about these processes that are adopted to deal with these really big problems, right, in which the nation itself is implicated, is that their models are extra-legal. I've been doing a bit of writing recently about constitutional ethics, drawing on Robert Cover's work and talking about the genre of the Commission of Inquiry report or the Royal Commission report. And those are reports that arise out of bodies that have a connection with the legal. There are often senior lawyers involved as the commissioner and so on, as was the case in South Africa. But they depart in significant ways from traditional legal forms because it's as though those traditional legal forms are inadequate, are unequal to the scale and complexity of problems that you see. So I think to try and heal rifts of that kind, we both need confession and atonement, and when that has to be done by the state rather than individual perpetrators, for example, because the individual perpetrators are dead, right, or most of them are dead, that becomes much more complicated. I know I'm not the only speaker today who's suggesting that much of the writing on forgiveness suggests that it operates in the realm between people. Much harder to operate in the realm between institutions and individuals, particularly when the individuals are dead. That said, there is certainly some of the sort of large body of writing on slavery reparations, which I just sort of touched on today, which suggests that processes of that kind are important. In Australia, recently, after the election of the Rudd government, something that had been called for a very long time in Australia, including in a report of the Human Rights and Equal Opportunity, that the Australian government apologise, right, for genocide, dispossession, all of these things. And the Howard government had sort of repeatedly refused to apologise. And one of the first things that Rudd did on coming to office was to apologise and said that's important in order to move this forward. But how do we frame that? Yeah, there's got to be a commitment there in the first place on the part of the perpetrators. If they're dead, who does it, right? And also I think you've got to look at the South African context as well, in the context of their particular historical and constitutional moment. It's part of a process that involved the making of the new South African Constitution. It's part and the non-forgiving of non-pardoning of some of the perpetrators and symbolic criminal prosecutions and so on. This is a package of machinery that is increasingly used in post-conflict states in order to try and build a viable state out of the ashes that remain. And as such, there's always an interest of the state in the interests of the state rather than in the interests of those who've suffered, who might need to forgive. So there's always complex questions about what are the virtues, who are the virtues, and to what extent this is a purely instrumental toolbox that's necessary for the consolidation of state power sort of going forward.
Could I add
the question?
just 30 seconds to that? My own reluctance to go very far, if at all, in the direction of personifying what we refer to as the state for purposes of being able to forgive, most of all in the case where the actual perpetrators are now dead, is that if one personifies the state for this purpose, one has to live with a personified state the rest of the time. And many of the greatest abuses of state power in modern history are the product of thinking of the state as a group person with rights and interests of its own that might prevail over those who are otherwise implicated in its common good.